Hello and welcome to this video on recent Supreme Court cases. The case we're going to be looking at today is the Independent Workers' Union of Great Britain and Central Arbitration Committee. This is a case from 2023 and it's a UK Supreme Court case. And this is a case about delivery riders and trade union rights. So first up, the facts and the background to the case. So the Central Arbitration Committee rejected an application from the Independent Workers of Great Britain, and this was to do with an application for union rights for delivery riders. Now, the decision was made because delivery riders were not seen as workers under Section 2961 of the Trade Union and Labour Relations Consolidation Act 1992. There was a number of reasons for this, the main one being that the riders could substitute someone else to carry out deliveries for them, so did not offer a personal service. Now, this was taken to the High Court and the Court of Appeal, both of which dismissed the appeal, and so it was appealed to the Supreme Court. So the outcome of the Supreme Court judgment was that the Supreme Court also dismissed the appeal. They held that the delivery riders are not in an employment relationship, and so, as argued, they do not have Article 11 European Convention of Human Rights union rights, which comes within Article 11, and so there was no right to have a compulsory trade union, although they did say that it is possible for them still to agree on a trade union, but not through the Article 11 rights. So, as I said, the Supreme Court dismissed the appeal, and delivery rights are not in an employment relationship for the European Convention of Human Rights law. So, they do not have compulsory union recognition. Now, this is the reasoning of the decision. So, Article 11 provides a right of joining a trade union, and this is a compulsory right. This is along with the right of peaceful assembly and freedom of association. But this only applies, in terms of the union right, this only applies where there is an employment relationship. And the decision of whether there's an employment relationship is decided by factors in the International Labour Organization Employment Relationship Recommendation 2006. So the court said the main factors within this were the performance of work and the remuneration and any form of payment. But there are multiple factors which we will look at in a moment in a commentary section. But there are multiple factors, and that the Central Arbitration Committee had actually decided correctly. They'd looked at the contract and the work in practice, and so these factors suggested that they were not workers, partly because they could substitute someone else to do the work. They had very much a large amount of flexibility of when they wanted to do the work. They had no obligation to be available a certain amount of times, and they could also work with the competitors. So let's just consider the reasoning of the case in more detail, and maybe evaluate it. So the main factors are performance of work and remuneration. What exactly does this mean? There are certain things which we could consider. This is whether the work is carried out for the company, whether there is integration between the employee and the workplace. Is the work performed for the benefit of the company? Is the work done personally by the worker? Is this a primary source of income? Does the worker have to make sure they are available? Does the worker receive any holiday? Now, looking at this, it might seem delivery riders are self-employed because they can decide when to work and work for competitors. They've got a lot of control over how they work. Maybe that's something to consider. But these factors are not the only factors to consider. These are just the suggested ones in the international law. So overall, it might seem that delivery riders do have more control than the company over what work they do, so maybe they are more self-employed. But also, some of the factors, like holiday pay, seem to be circular, because if they were arguing that they should receive holiday pay, they'd have to be asking the question of whether they are a worker, but part of deciding whether they're a worker depends on whether they get holiday pay. So that's kind of circular argument. Also, delivery riders are not really working in their own name, they're working for the company. If someone was complaining about them, they'd be complaining to the company, and not specifically to the rider. Also consider the Uber case, where certain drivers were not seen as third-party contractors. However, it should be noted that this case is slightly different. It's a more specific question about Article 11 rights, rather than a more broader question about workers in the Uber case. So the question is, does this reflect the reality, and should the rights be expanded? Some have argued that actually, these workers are in a more precarious position and yet do not have rights. Thank you for listening to this video of a recent Supreme Court case. If you'd like to know any more, you can read up on this on the Institute of Employment Rights website. And as always, if you have any questions, please contact me at at thelawguide@outlook.com. Thank you.